The Justice Varma case has brought back the focus of the entire nation on one important question of judicial transparency and judicial accountability. And leading the charge in this entire situation is one advocate who has gone to the topmost court of this country and raised this issue, not just today in light of this case, but even before, campaigning for judicial transparency and accountability. Today, I am joined by Advocate Mathew Nedumpara, who is the president of the National Lawyers Campaign for Judicial Transparency and Reform, who has been leading the charge for greater judicial transparency in this case. And today, he went to the Supreme Court of India and had a conversation with the Chief Justice of India, of all people, to demand this greater transparency in the courts. Sir, I welcome you and thank you very much for speaking to Republic TV. You went to the Supreme Court today and you had a very interesting interaction with the Chief Justice of India. What was it about?
See, what I asked the Honorable Chief Justice, we have filed a petition asking for immediate registration of an FIR of that incident which has happened in the residence of Justice Varma. So the notes, we have seen the currency notes being burned and how burned and it is being removed and all those things. So the reports change. Some media reports say 15 crore, some say 50 crore. But one thing is certain and undeniable, that there was illegal currency. And the first principle is, it is for the judge to explain how the money came there, and the possession of such a huge amount of money leads to the irresistible conclusion that all this money is corruption money, corrupt money, illegal money. And therefore, the first thing to be is for the police to register an FIR, and it is mandatory. Because the law requires that the police officer, that here it is under the Tuklak Road police station, the station house officer is under duty to register an FIR first. That is how to put the criminal law in motion. Then it is for the police officer acting fairly to decide how further to proceed with the investigation. And then the court's role is where, supposing that the investigation is not taken to its logical end, the police is not acting fairly, then the court can step in. Otherwise, the courts have no jurisdiction at all. The reason is the executive, the police is in its domain, is a sovereign, like in the same manner as the judiciary, in its domain is sovereign. The court exercises the sovereign function of the king, the sovereign, the judicial function, sovereign judicial function. The police does the sovereign policing function. These are two distinct concepts.
But the Supreme Court in its judgment in the Veeraswamy case, as we have discussed earlier, in 1991 has said that there has to be an in-house procedure. And the entire legal fraternity has been largely divided on this. We have seen bar associations across India, especially the Allahabad High Court Bar Association, vehemently protesting against the transfer of Justice Varma to the Allahabad High Court. They have also echoed the similar demand that an FIR in this case must be lodged. Yes. But the process of lodging an FIR against a sitting judge of the High Court is a very elaborate process that goes all the way to the top, to the Chief Justice of India. In this case, there are two sides. One which is arguing that the procedure is being followed, which is why your petition especially becomes very interesting. Why is the Supreme Court of India resistant towards going on and filing an FIR in this case? Their contention, to be the devil's advocate here, is that an in-house committee is inquiring, and indeed the 3 judges went there yesterday.
So let us talk about law first. The in-house committee is completely without jurisdiction. How the in-house committee came into existence? That is a creation of the conference of the Chief Justices of the High Courts and Chief Justice of India. So it is a informal body. The Conference of Chief Justice of India and Chief Justice of the High Courts is not a legislature. It is vested of no such lawmaking power. It is a private body, it's an informal body. And in-house mechanism can be about something else, about the conduct of cases, etc., quality of judgments, or such matters which are within the exclusive domain of the administration of justice. That in-house committee certainly can. But here, what the question before here is a commission of an offence. See, for instance, I do hope you don't mind my referring to Justice Gogoi's case. That allegation is sexual harassment. That has to be investigated by the police. And I can cite a case where in Kerala, and I won't name the judge, That is a case where a judge, a sitting judge, then he retired now, was accused of POSCO offence. And because the doctor noticed something, and immediately the doctor reported to the police. The police came, and the child named the judge. So the FIR couldn't be lodged. They lodged an FIR, but without naming the judge. The accused name was kept blank. So the investigation ended. So therefore, this complete misconception, the in-house mechanism for administrative issues, which is in the, there are many areas which in-house committee can consider. Suppose there are lawyers, complaints of lawyers about judges coming late to the court or not deciding cases on time. All those things can be misbehave or ill-behaving.
The judges do adjudicate a lot of serious matters, be it criminal or civil. So even if in this case, there is a 3-judge in-house committee that has been formed and it comprises of some very senior judges also. Why do you have any doubt in your mind vis-a-vis the efficacy of this investigation?
No, one thing, there are two aspects. One is the theoretical aspect, the legal aspect. The other is practical aspect. The judge, you said judges adjudicate. Adjudication alone is the judge's function. Investigation is not the judge's function. How a judge, suppose a murder take place, the police investigate it, they lay a charge sheet, and a trial is conducted. The judge then that comes to a finding, conviction, and thereafter imposes the sentence. Then that is by the trial court. Then comes the appellate court. And in criminal matters, Supreme Court has got only one jurisdiction, that of a final court of appeal. There is no original jurisdiction in criminal matters at all. Therefore, the in-house mechanism has no constitutional or legal foundation.
You have challenged the in-house mechanism at multiple occasions. In fact, you have been a firm proponent and your campaign has been for judicial transparency and reform.
Yes.
And one of the biggest reforms that has now been brought back into public scrutiny and limelight once again, especially after recent comments of Vice President Dhankar in Rajya Sabha, has been the NJAC.
Yes.
Do you really feel that the NJAC is a strong candidate replacement for this existing mechanism of judicial accountability?
No, two things. Again, I go to the legal aspect and practical aspect. See, appointment of a judges is an executive function. It is a matter concerning legislative and executive policy. It has nothing with the judges, nothing to do with adjudication. And then under the original constitution, the scheme is the president shall, in consultation with the chief, in the matter of appointment of High Court judges, for instance, president shall, in consultation with the Chief Justice of India, and such are the judges of the Chief Justice of the High Court, Governor of the High Court, shall appoint appoint by warrant. So the consultees, the Chief Justice is a consultee. The Chief Justice of the State Concerned is a consultee. The Governor of the State is consultee. So the State Government is involved, the Chief Justice is involved, and the Chief Justice of India is involved as a consultee. And this system worked very well. And the system where, this is an era where the executive was the appointing authority in law and in reality. And that system functioned well, because see, where the executive in the all of India's history, where the executive has deviated from the recommendation of the Chief Justice are only 7 cases only. There are hundreds of judges have been appointed. So the 99 cases, the government followed the government accepted the recommendation of the Chief Justice of India, Chief Justice of the State concerned, and the recommendation process comes where. So when the recommendation in the State High Court, the Governor, the Chief Minister, Governor means practically the Chief Minister. Chief Minister meets the Chief Justice and give names. And then see, the system worked very well. And the Chief Justice is not, the Chief Minister is not going to give any name which is totally undeserving. And that system worked. And in 1993, in Judges 2 case, the Supreme Court held that the Supreme Court held that independence of judiciary is a basic structure. See, it's very attractive to say so. And then they said the core of the independence of the judiciary is in appointments and not in the discharge of function after subsequent to the appointment. Because nobody could say that because the judge is completely protected. Under the constitutional scheme, a judge can be impeached, and to impeach a judge, a resolution has to be moved before both houses of the parliament in the very same session, and that resolution should have received the assent of 2/3 of the members voting. And that too after an inquiry is conducted under the Judges Inquiries Act. So the mechanism is so ironcast. And then a judge after his appointment, his service condition, nothing can be touched. So once I am appointed as a judge, I am completely protected. So independence of the judiciary cannot be said the discharge of the function subsequent to appointment is protected. Therefore, they said independence of judiciary is in appointments. Core of independence of judiciary is in appointments. And the core of the that core is protected when the opinion of the Chief Justice of India has primacy. Chief Justice of India is only consultee. I am a patient, go to a doctor, I ask his opinion. And the Chief Justice of India is only a consultee. Then they said the primacy of the Chief Justice of India, the opinion of the Chief Justice of India shall have primacy. And then further said the opinion of the Chief Justice of India is not his personal opinion, it is the opinion of the plurality of the judges. And how you arrive at the plurality? That is by a collegium of judges. That is how then the judgment came. And then they further said all unthinkable things. Then since the judges make this recommendation, then this is unquestionable. There is a judicial element in it, and the government cannot reject it. If the government has any objection, they can send it back, and the Collegium reaffirms it, they have to appoint it. And this judges 2 case by which the Collegium was introduced as the primary reason for the entire, I should say it is a cause for all malaise with the judiciary faces today.
All malaise, you say?
Yes. Till 1993, things worked well.
What went wrong?
See, Indira Gandhi, all these judgments came, Keshavananda Bharati judgment all came. During the judgments were written by judges appointed by the executive only. So we had the finest of judges who are very independent. In fact, Justice Khanna. So therefore, after Collegium came into existence by rewriting the constitution. See, judges have no power to rewrite a constitution. If I say if I use a Latin maxim or I say the English version, the province of the judge is to declare law and not to make law. Just desire non dere. Judges have no power to enact laws. If something is missing then they can supply it. If I say Latin maxim, then it may be difficult for the ordinary people to understand. So their interest is the court can supply. That lawmaking is in that narrow realm. Interpretation.
But the court did look at NJAC, which was a very powerful law which was passed by both houses of the parliament, had the presidential assent, and even had the approval of over 16 state assemblies. And yet, as you rightly explained, the basic structure doctrine and how the Supreme Court in its wisdom found out that it perhaps the appointment of the judges bringing in additional people into the NJAC format diluted the independence of the judiciary in some way. Do you really think that the courts, in light of case of Justice Varma and subsequent other cases of corruption which are now coming back to light, would look at this in a different point of view now?
No, let me see whether I'm a lawyer, so I am supposed to discuss the issues from a legal point of view. Practical aspect, I will come to that. The practical aspect, I tell you, the Collegium, when the judges start appointing themselves, they appointed their kith and kin. Their kith and kin, their juniors, and then the powerful politicians, governors, chief ministers, cabinet ministers, and all those people. And the really deserving first generation lawyers, they never were appointed. This is a chart which I submitted in the Supreme Court. In the NJAC case in 2015, I gave a chart, a progeny chart. Here this is a chart detailing the kinship progeny of the judges of the Supreme Court of India since its inception. This is a chart, you can have a look at it. This chart is part of an affidavit signed by me, which I filed in the Supreme Court in my petition in challenge of the senior designation system.
Yes, sir.
So therefore, the Collegium had led to a scenario of complete nepotism.
But is it uncommon? Is it not the case in other judicial?
No, I can tell you, in England there are only 2 cases where from the same family, a father and a son or a grandfather.
Only 2 in England?
Only 2. Nepotism is, I would say, India-centric. It is, and look at the chart, it is 100%.
But there is a case to argue that there might be more meritorious people coming.
No, 1 second, that is a system. Suppose you have an open selection. You advertise the vacancy, that is what we demand. The office of the judge is a public office. That has to be advertised. Applications has to be invited from everyone desirous. Then it has to be scrutinized, it has to be, then from among those, we may have to think of some mechanism of screening, and the selection be conducted by in a transparent manner on the basis of merit. So merit can be, a lot of things come under the merit: academic qualification, ability of drafting judgments, conducting the court, dealing with the public, so many issues are there. So that is the job of the commission. So NJAC in my mind had only one deficiency. There is only one national commission, which consists of the Chief Justice of India and 2 senior-most judges, and 2 members of the civil society, eminent men, to be nominated by a committee consisting of the Chief Justice of India, the Prime Minister of India, and the leader of the opposition, and the law minister representing the government. So we are a democracy. The appointment of judges is an executive function. Since that in that process, if the government, if nobody has a right to represent the government, then we are not a democracy. So law minister's presence is inevitable, unavoidable. So this committee was otherwise perfect. It was again I would say it was again a mini collegium where the judges had the primacy. What these people complained was the judges do not have an absolute control, because if 3 judges join together, the other 2 eminent members or the law minister, 2 of them oppose, then if 2 people can veto it. So therefore, what the judges feared was they would lose the absolute monopoly. And the NJAC in my mind had only had one deficiency, that in the state also you need a NJAC. So because the member of 6-member committee, it would have been difficult to select the judges for all the states, but that was not difficulty. See, NJAC was not allowed to take birth. When a legislation comes, from experience only you come to know its deficiencies, and that certainly can be cured. So this NJAC, it would have been like a UPSC, it would have been outside the jurisdiction of the court, an independent entity, would have advertised vacancies, they would have framed rules. The rules have to be made. And there is a difference between the court making rules and the government making rules. The government making rules, there is a consultation. In fact, in the courts also, in some of the high court, the rule making committee, they ask for invite application, etc. But there is a democratic process. So they would have, the only act was enacted. Even before it was notified, it was challenged. And who challenged it? The scorer, I am sorry to say, even if it is, say I am a lawyer, I don't want to displease people, but let them be displeased. Scorer is what? Scorer is there to please the judges. Scorer is a small community of lawyers who are acting as advocate on records, and they are before the judges every day. And the judges there exercise a discretionary jurisdiction. Literally 90% of SLPs are dismissed. And petitions are almost 100% dismissed, except where some PALs, etc. That is all publicity, litigation and other things. So therefore a judge, a lawyer before a Supreme Court judge is in a position of, in all humility, even if I am misunderstood, I have to say that, is the position of a beggar. That is a position of a beggar, they cannot displease it. There may be lawyers, who are of great eminence or stature and a lot of money they can afford to. I tell an instance, one of the lawyers with me, he disassociated with me, of my age only, because he found that after he became a part of our association, all his SLPs were dismissed. So he felt that he may become briefless. So lawyers are at the mercy of the court. So they cannot displease them. So SCORA is an association which cannot afford to displease the judges. And in
So what's
fact,
the solution? Let's say your petition is accepted. Let's say the Collegium system is done away with. Can the NJAC in its existing form make a return? What could be the possible one change?
First thing here is that if there is an executive government and the parliamentarians, they were to speak, Collegium will go in one minute. The reason is, look at that. It is a appointment of judges is not a judicial function, executive function. It's a matter of policy. It is not affecting anybody's right. The basic structure of all comes when somebody's right is affected. Basic structure is an absurd theory. If I have time, I will explain in 2-3 sentences. That is a North Star. Justice Chandrachud says a North Star. For me, it's a laughable theory. It serves the purpose of some Western interest. I will tell you the theoretical aspect. Let me come to the theoretical aspect, because as a lawyer, I should need to speak the theoretical aspect. The NJAC was in the realm of a legislative policy as to how the judges to be appointed. It is not concerning anybody's right. So the parliament, where when the parliament enacts a law, which I always say, we are all symbolically present. It is with our consent the law is enacted. And when it is ratified by the 16 states, then it has received the assent of both houses of parliament without only one member absenting or opposing. So it was the will of the people, and that law has been declared to be, and they use the word quash. Parliament has been reduced to an inferior tribunal by 4 judges. The opinion of the people at large, the 140 crore people, is being set aside, has been given to the dustbin, which that registration at the just in giving precedence of the will of the 4 judges. It is not a justiciable issue at all. If somebody's rights are infringed, you can come to a court. Who can come to a court? Simple logic, simple jurisprudence. Who can come to a court? A person whose rights are infringed. And if his fundamental rights are infringed, you can come to the Supreme Court without recourse to any other court. And then in the NJAC case, nobody said anybody's fundamental right is infringed. And the petition was not maintainable. From day 1 till the 31st day, I kept on raising this contention. Second issue is, assume for argument's sake, it is maintainable. Then the second question is to be decided, who are to be heard. SCORA is only a few lawyers in Delhi. If the lawyers are the real stakeholders, then lawyers are in different parts of this country. They ought to be heard. And the NJAC is concerning lawyers? Are the lawyers the real stakeholders?
So what's the solution then?
The real stakeholders is the public at large. And eventually they indirectly accepted my contention, and after striking down the act, the court invited the opinion or the public issued an advertisement, and 10,000 representation came. Can anybody consider this 10,000 representation? So that means if it is concerning everyone, every citizen of this country, and every citizen has a right to be heard, not SCORA alone, then it is not justiciable. My plea was that this issue, the challenge of the NJAC is not maintainable. It is not justiciable at all. It is absurd. And then this about this basis structure theory. This theory is taught in schools and colleges. I am so sorry that people of this country are misled. See, there are basis structure theory you can discuss in parliament. The secularism, federal structure, the constitution, all this. This is something which can discuss in parliament. It's relevant there. You cannot come to a court saying the basic structure is violated. You have to come to a court saying that my freedom of speech is infringed, my right to worship is infringed. So you have to specify an identifiable violation of a right, fundamental right. Then it is justiciable. So before Keshavananda Bharati's case, people came only to the Supreme Court saying that my rights are infringed. My freedom of speech, my liberty or my property or my is infringed. So right, remedy, forum. If I use a Latin maxim, ubi just ebi remedium. If you can come to a court if your rights are violated. If my rights are not violated, you cannot come to a court. So what is being done in the name of PAL is, say I am not naming anyone, or let me name Prashant Bhushan because he is fighting any number of PALs, and the one Upadhyay is there. He is fighting any number of PALs. They say, none of my rights are infringed. The basic structure is infringed. So these are not busybodies. I have never filed a petition in my life. I will never file it. This is a petition which I say, this petition which is, I am as a citizen is entitled to set the criminal law in motion. That is the concept of hue and cry. So therefore, this is an enforcement of my rights. I cannot come to a court unless I say I have some right infringed. So you don't have to say, if suppose tomorrow the parliament enacts a law which takes away the rights of I am from a minority community, or our rights are infringed, then you come to the court saying that our right is infringed, our freedom of conscience and faith is infringed. Say that. Why do you say the basic structure? So basic structure is, a concept is abused to achieve something which is otherwise cannot be uttered. Because how is it possible for common people to understand basic? It's very attractive. The term is very attractive. So this is all mistake.
Interesting points there, and basic structure doctrine, as we know, was one of the preliminary contentions for the rejection of
Keshavanandi Bharati's judgment rendered by 13-judge bench. See, that may be required for that particular reasons there. But the reasoning has no relevance.
We'll see what happens in the case of NJAC, but coming back to where we started for my last question.
Yeah, NJAC, what I say is that if the public opinion, if the press says, the parliamentarian says, so after all, judges are guided by public opinion. Today you saw the Arnab matter, a case where somebody grabbed a case involving grabbing of a child's breast, that the court said it doesn't amount to rape and all. The Supreme Court took suo moto, notice of it. So there it did was, the court is always, amenable to their public opinion. Public opinion actually shapes the court's decision.
And you went to the court. The public opinion has been requesting for greater judicial transparency in light of the Justice Varma case.
Now my problem is, the whole problem is, because of these two systems, the Collegium system and the senior designation system, the bar has become, I am using a very strong expression, spineless.
But we have seen a lot of bar associations.
Generally speaking, independence of the bar has been lost. The senior why I oppose senior designation system is that make the bar subordinate to the judges. Bar was the fourth estate in the times of Blackstone. Blackstone in the 18th century. Then the press was not very important. Bar was the fourth estate. Church, the king, executive and the church, parliament and the fourth estate was the bar. Today what is the position of the bar? You go to a Supreme Court, the highest paid lawyer in this country will say, I ask a question to myself. The question I raise is, that is what a lawyer should say. We need to respect the court. We have to be courteous to the court, we have to be respectful to the court. That does not mean they have to be servile. Therefore I can see, from 79 I am seeing the bar, and today I am seeing the bar. There is the complete, there is a great difference. Lawyers has become fearful. The scenario is today, and then the gross abuse of the contempt of court jurisdiction. See, this contempt of court jurisdiction is something in the 19th century was considered to be obsolete in England. They said it is only relevant in coloured people, where there is not much of a respect for the judiciary. So we must pay the greatest of respect and to the court, the highest of decorum need to be maintained. But that does not mean the people and the lawyers becoming slaves. So when it comes to corruption, see, you ask go to the bar, what the lawyers speak in a hushed up manner. Now it is no longer hushed up. There is rampant corruption, that is a perception. And I tell you, privately I show you many instances, many records I have. in 2010, and in fact, I was the first person to write a letter seeking investigation into the KG Balakrishna's corruption, then Chief Justice. And where we need to see, 27 times he travelled to Dubai when he was a Chief Justice of India. And under the Right to Information Act, I obtained that information. So in 2010, I wrote a letter about a particular judge and giving the name of the conduit and all. Then I had to face certain difficulties, which I don't tell me. So therefore, there is a difficulty for those who, raise these issues.
Coming back to the question at hand, sir, and I have time only for one more question.
Yes.
But this is such a nice and interesting conversation. Today, you said that the Honorable Chief Justice of India did not give you a clear reply in a matter of immediate listing in the Justice Varma case. You are seeking an FIR in the matter. Your final thoughts on why this case should be heard at the earliest by the Honorable Supreme Court?
No, I say I have the greatest of regard, and you can say an affection to Chief Justice Sanjeev Khanna. He doesn't talk much of a meter. It's not a sweet talker, but it's, I believe, an upright man. His lordship is the scenario is pretty difficult. See, his lordship would really agree with me. This matter cannot be investigated by the committee. Committee has no legal authority to do it. And practically, from the practical aspect, it's a job. Police constable's job. Murder takes place. Will the judge go and investigate the spot? Postmortem, will the judge conduct it? That is police job. So Chief Justice of India, his lordship will certainly, I am sure in the heart of the heart, agree with me. And now, see, I am a free bird, so I can speak. He is still part of the institution. So the Berlin wards are created on all sides. So that may be the reason why his lordship has not been able to immediately respond. I wanted a date. And I expected that. I wanted a date tomorrow. I came prepared to stay for Delhi today. So that is what
you get the urgent listing that you are seeking for. But at the moment, sir, I thank you very much for your time. Ladies and gentlemen.
Then one word can I say?
Please go ahead, sir.
Yes. Then one thing I tell you, see, Justice Khanna, his lordship has been pleased to upload that burning notes. That is a great thing. I salute him. And I will say that, we had many Chief Justices. I have been closely watching them. And I have only to say something good about Justice Khanna.
Indeed, and that was a brave move made by the Supreme Court of India, and we hope that the matter that you're bringing up as far as the listing of this matter is concerned, we'll be closely watching the Justice Varma case. Ladies and gentlemen, that was Mathew Nedumpara leading the charge for judicial transparency and accountability. We'll be tracking more updates on the Justice Varma story. In the interim, thank you very much for joining us this evening.